I have never done anything professionally other than represent homeowner associations, condominiums, and planned communities for 15 years. I'm one of the bad guys, according to many people who come down here and talk to you. And I want to tell you today that the bill is fundamentally flawed in its language. And I'll tell you that that actually helps me as a lawyer. I'm here as a volunteer lobbyist, volunteer with the Community Associations Institute. I'm not representing a client, but if I were acting in self-interest, I'd tell you to vote for this bill because the language is very unclear, very ambiguous, and I'm going to tell you exactly why this bill as drafted is a significant problem. The word parking never appears in the bill. The word vehicle never appears in the bill. The bill is full of broad language such as regulate and authority. With the proposed amendment this Bartow agreed to, I'm going to read what the bill says using some ellipses, a sort of fifth grade grammar exercise to tell you a very simple statement of why this bill is problematic. It says as follows: notwithstanding any provision in the governing documents, which means you're trumping the CC&Rs, notwithstanding any provision in the community documents, the association has no authority over and shall not regulate any area for which the use has been dedicated to a governmental entity. I've got 3 clients that I use as examples to tell you why this is a huge problem. I have one that has a major swimming pool that is used by an adjacent school district for their swim team. That is the use, the dedication to a governmental entity, the school district, of an area that the association has now no more authority or jurisdiction over. That's nonsensical. That when an association gives use of its common area owned by the association to a governmental entity, such as a school district or the swim team to use, that act of giving that area a use agreement to a governmental entity would then mean that the association has no authority and cannot regulate its own pool. Second example are utility easements. Easements granted to the government for utilities, often over common areas owned by the association. The use of that common area by virtue of an easement to the governmental entity would mean that the association has no authority over or control over its own property that may be burdened by an easement. And finally, there are many of my clients that are next to elementary schools, and they enter into use agreements whereby the children can play during recess on an adjacent common area. Once that common area is dedicated in use to a governmental entity, the school district, the association, by virtue of this bill, would have no ability to regulate or authority over it. Now, Ms. Bartow's response to this, of course, was, well, then the entity, the governmental entity and the association can simply contract again over the bill. Once it's enacted into law, you can say, well, the statute says we have no authority over any area we dedicate to you, but we'll simply contract over the statute again. But the problem with that is you all would be saying, no matter what the contract says, the CC&Rs, your statute prevails. So to say we're trumping the contract, but once we put the statute in effect, you can trump the statute with another contract is not the way the situation works. The part of Ms. Bartow's comments that's confusing to me is that she says that Arizona statutes say currently that associations do not have authority over public roads. We have to differentiate between whether the association has the ability to maintain the road, which nobody would argue they do, and the association's ability to enforce a contractual provision where a homeowner has promised not to do something. That's what we're talking about here. Because when a homeowner buys into an association and they agree to the contract, what they're saying is, I may have the right to paint my house purple if I'm in a county area. I may have the right to erect a gazebo in the front yard, but I choose not to. I agree not to. I promise to my neighbors I will not. One of the promises that one makes when they buy into a community association is, I won't park my RV in front of someone else's house. That's a promise. It's a contract. It has nothing to do with the roadway or exercising jurisdiction or authority over the roadway. So I urge you to vote no for this if for no other reason than it purports to restrict parking of vehicles, never mentions the words, And by using the simple art of ellipses, which is a fifth-grade grammar construct, it is apparent that this bill, as drafted, goes way too far to nullify association restrictions and agreements with governments that is certainly not anyone's intent. Their role in enforcement in the Sun City West area is a strange construct of the governments that was set up almost 25 years ago, and by simple legal reality, they do not fit the definition of a planned community under the statute. Rec Centers of Sun City West, another entity out there, does, and so even though this statute would not technically apply to PORA, it would apply to the underlying use restrictions that the Rec Centers of Sun City West.
Well, actually, Mr. Chair, the testimony we heard doesn't actually apply to them. I mean, I appreciate the fact that they came to testify, but is that true?
The enforcement of the use restrictions in Rec Center in Sun City West is the dual obligation or the dual option of PORA, the entity Mr. Woods represents, and the Rec Centers of Sun City West. Mm-hmm. And when if this
Mr. Chair, the PORA that Mr. Woods is the president of, right, wouldn't be affected.
Probably not. I hadn't given much thought before today.
Okay. All right. So just so you know, I appreciate the citizens coming down, but it doesn't. You know, it's a little bit neither here nor there for those of you who either represent Sun City or so forth.
Senator Harper, to that point. And so, with your example of the pool being used by the adjacent school, the offending words in this particular language that include that pool under this law are "or use." And I'll read it in context so that everyone can understand. Notwithstanding any provision in the community documents, an association has no authority over and shall not regulate any roadway, easement, or other area for which the ownership or use has been dedicated to a governmental entity. And so if we remove the two words, or use, in other words, it would then read, for any roadway, easement, or other area for which ownership has been dedicated to a governmental entity, would that fix that particular problem?
It would.
Thank you.
Senator Waring. Mr. Chair, Senator Gray talked earlier, because I know he's run this bill a couple times, but his experiences as a police officer. Why doesn't that work?
Well, it's a question of proximity and timing. A lot of people move into associations because they've had experiences in non-HOA realms where the reliance on the municipality or the county to enforce zoning codes is not as fast or quick as what they would have expected. And so they say, you know, I used to live in a county island, and my neighbor had an RV that they parked in their backyard, and I called the county, and for whatever reason it didn't violate an ordinance or whatever. And so they say, I don't want to live next to fill in the blank XYZ, whatever the conduct is. And so they move to an HOA. And when they do that, they're entitled to the benefit of their bargain. And one of the bargains they strike with their neighbors is, we don't want RVs on the street in front of our house, and when they appear there, we want the HOA to be able to deal with it quickly, rather than according to the timing of the local ordinance or the county ordinance or the whatever else is in effect there. That's their right to bargain for that. And so it is true that in municipal areas or in county areas where it's a priority for local law enforcement, it would seem redundant for an association to need to enforce this restriction when, quote, the city or county should be doing that or could do that. But in the area of shrinking budgets and other problems, it's unclear that we could expect that the city or the county would be diligent on such a matter as this, which in a priority situation is certainly not above investigating crime, domestic violence, and things like that. So the association's use
Mr. Chair, I guess then I would ask you, when you send out your information about these things, maybe don't overstate in the future.
Well, Mr. Chair, Mr. Waring,
we will clarify for the record. I think travesty was not my bill.
No, not Mr. Chair, Mr. Waring, I will
apologize for my wandering syntax.
Travesty was the injustice that I committed.
Yes. It was good that you fixed it, yes.
Mr. Chair, Mr. Waring, I will tell you that these have been the worst thing that the legislature could have done to HOAs in recent memory.
Thank you, Mr. President. This gentleman, if you could come up and give us your name.